legacy of impartiality and integrity. His Lordship has always enjoyed and maintained a constructive and congenial relationship with the Bar and his brother. Honorable Chief Justice Qazi Faiz Isa, Honorable Senior Puny Judge Sardar Tariq Masood, Honorable Judges of the Supreme Court, Mr. Riyazat Ali Sahar, Vice Chairman Pakistan Bar Council, Mr. Shahzad Shaukat, President Supreme Court Bar Association, respected members of the Bar, ladies and gentlemen. Today we have assembled to bid farewell to Mr. Justice Sardar Tariq Masood, a distinguished judge of the Supreme Court of Pakistan at the end of a long and illustrious judicial career. His Lordship served with great distinction for more than 8 years in the Supreme Court and prior to that for over 6 years in the Lahore High Court. Each and every day, His Lordship has faithfully pursued and advanced the ideals of law and the legal profession. Judgments authored by His Lordship are models of clarity, no matter how complex the issues and how lengthy the facts, therefore ensuring that judgments can be easily comprehended by the parties and the public. With a vast experience spanning over 3 decades, first as a lawyer and then as a judge, His Lordship leaves behind a legacy of impartiality and integrity. His Lordship has always enjoyed and maintained a constructive and congenial relationship with the Bar and his brother and sister judges. During his time as an advocate, he was elected President of the District Bar Association Rawalpindi, and during his time on the bench at Lahore High Court, he discharged his administrative duties as Inspection Judge for several districts, Member Administration Committee Lahore High Court, and Administrative Judge, Labour Courts, Drug Court, and Consumer Protection Courts. His Lordship boasts an impressive disposal of 13,624 cases as the presiding judge and was member of benches deciding 20,582 cases in the Supreme Court, thus ensuring speedy resolution in matters pertaining to life and liberty of the parties. His Lordship has made significant contributions to the development of criminal jurisprudence and will therefore leave a huge void to be filled. His legal prowess over criminal law is unparalleled and enjoys recognition amongst the legal fraternity as well as the judiciary. This has been evident from the judgments rendered by His Lordship. In the case of Javed Iqbal versus the State, reported as 2023 SCMR 139, Honorable Mr. Justice Sardar Tariq Masood, speaking for the bench, made an important observation qua the admissibility of judicial confession in the following terms. The prosecution must prove its case against the accused beyond reasonable doubt, irrespective of any plea raised by the accused in his defense. Failure of the prosecution to prove the case against the accused entitles the accused to an acquittal. The prosecution cannot fall back on the plea of an accused to prove its case. Where the prosecution succeeds in establishing its case against the accused beyond a reasonable doubt, then the stage arises for consideration of the plea of the accused in defense and the question of burden of proof becomes relevant. Before the case is established against the accused by the prosecution, the question of burden of proof on the accused to establish his plea in defense does not arise. However, if the court decides to convict the accused on the basis of his confessional statement or his plea under Section 342 CRPC, then it is not open to the court to accept a part of the statement of the accused and reject another part for the purpose of convicting him for the offense. The judgment also appreciates and expounds the importance of the standard and mode of keeping evidence in custody in cases pertaining to narcotics. His Lordship also reiterated the role and responsibility of the prosecution in demonstrating that all steps in the handling of physical evidence, including recovery, packaging, safekeeping, and transmission to a laboratory, are properly followed. In another case, also titled Javed Iqbal versus the State, reported as 2023 SCMR 401, authored by His Lordship, provides guidelines on the issue of disapproving the grant of bail to an accused on certain conditions whilst upholding the right to liberty of the accused. The judgment is an important milestone in elucidating the link between the right to liberty and pre-trial detention expressed by His Lordship in the following terms. When bail is granted to an accused, not as a mean of enforcing recovery of fine, but on its own merits, the same could not be made dependent on the payment of fine. Any such condition would amount to curtail his liberty for which he otherwise is entitled. Grant of bail cannot be subject to riders and conditions, if otherwise a case stands made out. and an accused seeking bail after submitting bail bond through sureties desires transfer of his case to his sureties, custody to his sureties who undertake his production as and when required by the court, and for that he has to make out a case in accordance with the law applicable thereto. He cannot be allowed or required to barter his freedom, and imposing any condition other than submission of sureties would be against the dictum laid down by this court. The judgment serves as a testament to his lordship's resolve to always ensure that the accused is not denied liberty, even though the same may sometimes translate into decisions that may not always be popular, but are always proper and within the confines of law and fundamental rights enshrined under our Constitution. Retirement is mostly synonymous with endings and sadness. However, it is rather a time for celebration and introspection, an opportunity to experience going away having earned the respect of your peers, whilst maintaining integrity and dignity in times of adversity. There is no greater honor than to serve the public and to discharge one's duty with integrity, without fear or favor. Finally, it would be an oversight on my part to not mention the candor and witty demeanor of His Lordship. I bid farewell to Mr. Justice Sardar Tariq Masood and wish him well with health, prosperity and contentment. Thank you, sir. Thank you for your time in this court. I personally am very grateful to have appeared before your Lordship in several of the matters. Thank you, sir.
Thank you, Attorney General. Now I would request Mr. Riazat Ali Sahar, Vice Chairman, Pakistan Bar Council, for his address.
Bismillahirrahmanirrahim. Mr. Justice Qazi Faiz Isa, Honorable Chief Justice of Pakistan. Mr. Justice Sardar Tariq Masood, Honorable Senior Peony Judge, Supreme Court of Pakistan. Mr. Justice Mansoor Ali Shah, Honorable Judge, Supreme Court of Pakistan. Mr. Justice Munib Akhtar, Honorable Judge, Supreme Court of Pakistan. Mr. Justice Yahya Afridi, Honorable Judge, Supreme Court of Pakistan. Honorable Judges of the Supreme Court of Pakistan. Mr. Mansoor Usman Awan, Attorney General for Pakistan and worthy Chairman, Pakistan Bar Council. Learned members, Pakistan Bar Council. Mr. Shahzad Shaukat, President, Supreme Court Bar Association. Distinguished members of the Bar Councils and office bearers of the Bar Association, learned members of all the bars, ladies and gentlemen, Assalamu alaikum. As we gather to bid farewell to one of our most esteemed judges, Mr. Justice Sardar Tariq Masood, we embarked upon a journey of reflection, remembrance and celebration. For around 4 decades, Mr. Justice Masood has played a crucial role in the bar and the bench. He remained a steadfast guardian of the rule of law and a beacon of integrity in the legal fraternity. Born in 1959 in the village Saroha, Tehsil Kallar Sayyada, district of Rawalpindi, Mr. Justice Sardar Tariq Masood began his journey in the legal realm after completing his Bachelor of Law, starting his career in advocacy in 1985 in district Rawalpindi. Quickly rising through the ranks, he was enrolled as an advocate at High Court in 1987, laying the groundwork for a career defined by excellence. By 2008, he attained the prestigious rank of Advocate Supreme Court of Pakistan, reflecting his exceptional legal expertise and unwavering commitment to justice. Beyond his courtroom achievements, Mr. Justice Masood also demonstrated exemplary leadership as President of the District Bar Association, Rawalpindi, embodying principles of democracy, fairness, and equality before the law. In 2009, Mr. Justice Sardar Tariq Masood's career soared as he became an additional judge of the Lahore High Court, where he delivered numerous groundbreaking judgments, showcasing his profound legal acumen and steadfast dedication to justice. His significant contributions to jurisprudence during his period have left an enduring impact on the nation's legal framework. In 2015, his career culminated with his appointment as a judge of the Supreme Court of Pakistan, where he continued his tireless pursuit of justice, unwavering commitment to upholding the rule of law, and dedication to serving the people of Pakistan with honor and dignity, with honor and integrity, solidifying his legacy as a distinguished legal figure. Mr. Justice Sardar Tariq Masood is renowned as a leading authority on criminal laws in Pakistan. His notable contributions included the seminal case of Muhammad Ajmal, reported in 2022 as SAMAA page 88, wherein he elucidated the distinction between Section 302B and Section 302C of the Pakistan Penal Code. Through his case, Justice Masood delineated how the elements of both sections influence the sentencing of the accused. For instance, in the instant case, the interpretation of these sections led to a significant alteration in the sentence, reducing it from life imprisonment to 17 years of imprisonment. This landmark case not only clarified legal nuance but also underscored Masood's expertise in criminal jurisprudence. Unfortunately, many trial judges seem to overlook the fundamental right of the accused to seek bail, disregarding the principle of innocent until proven guilty. Despite the provisions laid down in the CRPC, accused individuals are often kept in custody for extended periods, even before charges are formally framed against them or during prolonged judicial proceedings. However, it is heartening to note that judges like Mr. Justice Sardar Tariq Masood, one of the most esteemed judges in Pakistan, have consistently upheld the principle of bail. In the landmark case of Javed Iqbal, reported in 2023, CMR page 401, Honorable Mr. Justice Sardar Tariq Masood not only granted bail but also provided a comprehensive elucidation of bail and procedures, reaffirming the right of the accused to seek bail unless there is a credible threat of interference with judicial proceedings. His judicious application of the law serves as a beacon of justice in ensuring that the rights of accused are upheld within the legal system. The nine judges bench, including Mr. Justice Sardar Tariq Masood, headed by the Honorable Chief Justice of Pakistan, demonstrated judicial awareness in their handling of the presidential reference pertaining to the Zulfikar Ali Bhutto case. This landmark case set a precedent by highlighting the importance of fair trial standards in judicial proceedings. The court's acknowledgement of constitutional and legal lapses in the trial of Zulfikar Ali Bhutto, which failed to adhere to the standards of fair trial and due process, is highly appreciated by both the legal fraternity and the public. Pakistan Bar Council, being the apex body for lawyers, vehemently condemn the ongoing social media campaign targeting honorable judges. While it is acceptable to criticize a particular judgment, it is entirely unacceptable to launch personal attacks and engage in character assassination against honorable judges via social media platform. Judges have consistently upheld the rule of law and demonstrated an unwavering commitment to justice. A recent example of such reprehensible behavior is the malicious and slanderous campaign against the Honorable Chief Justice of Pakistan, Mr. Justice Qazi Faiz Issa. This campaign aimed at tarnishing the reputation of the Supreme Court and undermining the credibility of the Honorable Chief Justice of Pakistan is founded on deliberate distortions of a Supreme Court decision. It is unacceptable for the court's decisions to be manipulated for political purposes, and certain individuals have resorted to spreading false and fabricated information to incite violence and foster hatred. I would like to utilize this platform to highlight the symbiotic relationship between the bar and the judiciary. It is crucial to recognize that bars, particularly the Pakistan Bar Council, serve as vigilant observers of the judiciary. Any feedback provided by the bar, especially the Pakistan Bar Council, carries significant importance as we, the legal fraternity, are dedicated to the improvement and achievement of the judiciary. Lawyers have consistently been at the forefront advocating for the preservation and advancement of the judiciary. In addition to the concerns highlighted earlier, I would like to draw attention to the matter concerning the framing of rules of the Judicial Commission of Pakistan. It has been brought to the attention of the Pakistan Bar Council that amendments to the rules of the Judicial Commission of Pakistan have been drafted by the subcommittee of the Judicial Commission of Pakistan. I trust that a meeting of the Judicial Commission of Pakistan will be convened promptly to approve the amendments proposed by the subcommittee. Furthermore, there is an urgent need to address the issue of vacant positions, particularly the 22 vacancies in the Lahore High Court and 8 vacancies in the High Court of Sindh. We extend our appreciation for the recent judgment delivered by the Supreme Court concerning the critical issue of the Supreme Court Practice and Procedure Act 2023. In this landmark decision, the Honorable Chief Justice demonstrated a commendable commitment to upholding democratic principles by limiting his own powers and advocating for the legislative process of Parliament. This proactive stance promotes transparency and accountability within our legal framework, fostering a healthier democratic environment. We express our appreciation for the initiative undertaken by the Honorable Chief Justice to streamline the process of case fixation in the Supreme Court. However, while acknowledging this positive step, we believe there is room for further improvement. We also commend the issuance of cause lists for a period of 1 month and the formation of benches for the same duration, which enhance transparency and efficiency within the judicial system. As we bid farewell to Mr. Justice Sardar Tariq Masood, let us not mourn the culmination of a distinguished career, but rather celebrate the enduring legacy of legal luminary whose contributions to the cause of justice all resonate for eternity. Let us draw solace from the knowledge that though his lordship may be retiring from the bench, his legacy shall endure as a beacon of hope and inspiration for generations to come. In conclusion, let us extend our heartiest gratitude to Mr. Justice Sardar Tariq Masood for his decades of service to the cause of justice, his unwavering commitment to upholding the rule of law, and his profound impact on the legal landscape of our nation. By the grace of Allah Almighty, may his retirement be blessed with peace, prosperity, and the warm embrace of the loved ones. Amen. Thank you, sir. Highly obliged.
Thank you, Zahir sir. I would now request Mr. Muhammad Shehzad Shaukat, President, Supreme Court Bar Association, to speak on this occasion.
The Honorable Chief Justice of Pakistan, Justice Qazi Faiz Isa, Justice Sardar Tariq Masood, the Honorable Senior Puny Judge, Honorable Judges of the Supreme Court of Pakistan, Mr. Mansoor Usman Awan, Attorney General for Pakistan, Mr. Riazat Ali Sahar, the Honorable Vice Chairman of the Pakistan Bar Council, members of the Bar, ladies and gentlemen, Assalamu alaikum. Certain amazing figures were given today vis-a-vis the disposal of cases by His Lordship Justice Tariq Masood by the Attorney General for Pakistan, and I was for myself startled by the figures. It is unfortunate that the disposal made by our honorable judges is not statistically appreciated by everyone in this country. Nobody realizes how many man-hours a judge puts for dictating judgments. I mean, 20,000-30,000 cases is an unbelievable figure for me as a very humble officer of this court. Sir, we are grateful to you for the time given to by your lordship to the cause of the judiciary. But may I point out here, sir, that your honors will always be recognized as a judge who spoke through his judgments alone. And we would request the Honorable Supreme Court of Pakistan, the other honorable judges, to be more in pointing out things through their judgments than the discourse in the courtrooms. That will save time for everyone and will, of course, add to the grace and dignity of this august court. His Lordship's entire career has been given out by the speakers before me, so I will not delve upon that. But may I add that Your Lordship's judgment, I have gone through them one by one, starting from the 2016 SAMAA judgment, page 467, and coming to 2024 SAMAA, page 43. May I add that despite the fact that Your Lordship was mainly dealing with criminal cases, each one of these judgments actually lays down a rule of law, and that is clearly appreciative of my Lord's competence and ability to handle all kinds of cases. Here, the Supreme Court Bar Association expresses its gratitude to the Supreme Court of Pakistan for handling of the presidential reference in the case of Mr. Zulfikar Ali Bhutto. And as I said day before yesterday as well, it takes courage to admit a mistake, and that too by the apex court. But that judgment that Your Lordships rendered will go down in history as a landmark in dispensation of justice to people of this country. May I now take Your Lordship's time in pointing out that there are certain issues which require immediate attention of this august court. First one of them is the issuance of the fortnightly final cause list that we have been requesting for a while now. If Your Lordships can actually look into this aspect of this administrative affair, issuance of a fortnightly final cause list can help us lawyers be ready with the schedule of our cases in the next 15 days, so that there will be less adjournments and more work that can be done. Similarly, Your Honor, we are grateful for the issuance of monthly proposed cause list, but the Supreme Court Bar Association is pained to point out that a large number of the cases given in the proposed cause list do not make it to the final cause list, and that actually affects the plan that the lawyer has created for himself in appearing before this court and addressing those cases with promptitude. So may I request Your Lordship to please have a look at this aspect of the case. Similarly, the question of senior advocates and their handling has been begging attention of this court for a while now. It has been a long time that this Honorable Court has bestowed the status of senior ASCs on lawyers. And it is not that our lawyers are no longer capable of being given the title of the senior ASCs. But may I also point out that the rules of this court actually give a right of prior audience to our existing senior ASCs. And that is a practice that is no longer being followed nowadays. And it is high time that we bring back that glorious tradition of giving precedence to our senior ASCs. And as is a landmark of my Lord Justice Faizi said, he gives up his discretion as early as possible. So may I also point out that it is Your Lordship's discretion to decide as to who becomes senior ASC of this court. And the rules may be suitably amended to even structure that discretion if it is possible. And lastly, may I also point out that the vacancies in all high courts are now seriously affecting the working of those courts, especially that of Lahore High Court from where I come. And 22, now 23 seats are lying vacant. And all of us, we are awaiting the rules to be framed so that for myself, and I know I'll invite the wrath of Pakistan Bar Council, but I am not very keen on seniority. I am more keen on having more competent judges in this court and also in the high courts. So Your Lordships will, it is our request, immediately advert to the rules and then take up the issue of elevation of the judges to the respective high courts and to this court. Lastly, may I also point out that two of the honorable judges sitting here were instrumental in causing the amendments in the CPC by the Lahore High Court. My Lord Justice Mansoor Ali Shah was the Chief Justice of Lahore High Court at the time. He started it, and Justice Aminuddin Khan was, of course, the President of the Rules Committee who carved out those amendments. But my Lords, it is the law of the land today, and not a single provision of the amended CPC is being implemented. It is unfortunate that we are defying our own laws. I don't know for whatever reason, and the trials, hundreds and thousands of them, which are now taking place at Punjab, are practically illegal because they are not in accord with the amended CPC. So your Lordships will graciously, because dispensation of justice is the ultimate goal that this Honorable Court has to address. And if all those trials end up in cases of remand, it will be unfortunate. So may I request particularly Justice Mansoor Ali Shah to please have a look at this and advert to this very serious question. Similarly, my Lord, we have been pointing out from day one that I have assumed office of the President of Supreme Court Bar that the video link facility of this August Court is a genuinely good thing to happen to lawyers. And I've been requesting that this, not only that the system be upgraded, it may also be extended to the benches of the high courts wherever they are in the country. That will save time for the lawyers. They would not have to travel to the principal seat, and they will simultaneously be working in the respective high courts as well. That will, of course, help us in the ultimate goal of having expeditious justice for all concerned. Now I come to the last point, that is that the elections have already been undertaken. I know there are legal challenges to those elections, and those challenges will be dealt with by the courts of law and the tribunals as and when they are approached. But I take this opportunity to make a request to all the stakeholders by the virtue of the pedestal that I am holding right now, to please bring precedence, give precedence to this country first. And I ask them to come together to ensure that our country moves forward and we come out of petty disputes. It is an honor to say farewell to you, sir, and I will for myself always remember you as someone who was compassionate, very benevolent, and a most courteous person that I've ever seen. We will miss you, sir, but as has been said, every good thing has to come to an end. So I wish you all the best in life, sir, and Supreme Court Bar will be welcoming you once again whenever you feel like coming to us. It is an honor to have the right of audience before this August forum, and for a change, no question coming from the bench. I'm honored, sir, grateful.
Thank you.
Thank you, Shehzad Shaukat sir. I would now request Honorable Mr. Justice Sardar Tariq Masood sir for his address.
Bismillahirrahmanirrahim. Izzat Maab Janab Justice Qazi Faiz Isa Sahab, Chief Justice of Pakistan, Nai Qable Ehtaram Brother Judge Sahiban, Father Attorney General for Pakistan, Father Naib Chairman, Pakistan Bar Council, Father Sadr Supreme Court Bar Association, Qable Ehtaram Ohdedaran, Warakin Bar, Khwateen Wazrat. कदीमी रवायत के तौर पर हम आज से पहले कई मरतबा इस नौइयत की तकरीबात में शिरकत कर चुके हैं, जो कि अदालत उज़्मा के किसी जज साहब की मुद्दत मुनसबी की तकमील के मौका पर मुनक्कद की जाती है। आज की तकरीब जहाँ पर कानून इंसाफ के शोबे से ताल्लुक़ रखने वाली नामवर शख्सियात मौजूद हैं, से खिताब करना मेरे लिए बाइस एज़ाज़ है। मैं इस वक्त तमाम हाज़रीन का तहे दिल से मशकूर हूँ जो अपनी मसरूफियात के बावजूद इतनी कसीर तादाद में यहाँ तशरीफ़ लाए और इस तकरीब को रौनक बख्शी। آپ سب لوگوں کی آمد میرے لیے باعث افتخار، خاص طور پر جناب اٹارنی جنرل فار پاکستان، جناب نائب چیئرمین پاکستان بار کونسل اور جناب صدر سپریم کورٹ بار ایسوسیشن کا بھی مشکور ہوں کہ انہوں نے میری کاوشوں کو اتنے اچھے الفاظ میں سراہا جو ان کی محبت کی عکاس ہے۔ جیسا کہ آپ کو بخوبی علم ہے کہ میری قانون انصاف کے پیشے سے وابستگی تقریباً 4 دہائیوں سے، جس میں تقریباً 24 سال بطور وکیل اور تقریباً 6 سال بطور جج لاہور ہائی کورٹ اور 8 سال سے زیادہ بطور جج سپریم کورٹ بشمول ایکٹنگ چیف جسٹس آف پاکستان شامل ہے۔ میں نے اپنی ابتدائی تعلیم گورنمنٹ پرائمری اسکول بٹاہڑی سے حاصل کی۔ اس اسکول میں اس زمانے میں صرف ایک ہی کمرہ ہوا کرتا تھا جو کہ 5ویں جماعت کے لیے مختص تھا، جبکہ دیگر تمام جماعتیں کھلے آسمان تلے بیٹھتی تھی، یہاں تک کہ بیٹھنے کے لیے ٹاٹ کی دریاں بھی دستیاب نہ تھیں اور بچے اپنے بیٹھنے کے لیے گھر سے بوری لے کے جاتے تھے، اور گرمیوں کے موسم میں وہاں موجود ایک آم کے درخت کے نیچے ہماری جماعت بیٹھا کرتی تھی، اور جب بارش ہوتی تھی تو اسکول میں چھٹی ہو جاتی تھی۔ پھر گورنمنٹ بوائز ہائی اسکول کلر سیدان سے 6ٹھی جماعت سے میٹرک تک تعلیم حاصل کی۔ پہلی مرتبہ 6ٹھی جماعت میں انگریزی زبان سے واسطہ پڑھا اور ہمیں ABC پڑھائی گئی۔ اس کے باوجود الحمدللہ میں نے نہ صرف فرسٹ ڈویژن میں میٹرک کا امتحان پاس کیا بلکہ پورے اسکول میں پہلی پوزیشن حاصل کی، اور میرا نام ہیڈ ماسٹر صاحب کے کمرے میں آویزاں آنرز بورڈ پر پہلی پوزیشن لینے والوں میں آج تک موجود ہے۔ گورنمنٹ کالج کلر سیدان سینٹر کا امتحان پاس کرنے کے بعد عسکر مال کالج راولپنڈی سے گریجویشن کی اور پھر سندھ مسلم لاء کالج سے قانون کا امتحان پاس کیا۔ اس زمانے میں جناب حزیق الخیری صاحب اس کالج کے پرنسپل تھے، جو کہ بہت ہی شفیق انسان تھے۔ ان کے علاوہ دیگر تمام اساتذہ نہ صرف بہت ہی قابل تھے بلکہ نامی گرامی وکلاء تھے، جنہوں نے قانون کے مختلف مضامین میں ہماری بہت اچھی رہنمائی فرمائی۔ 1984 میں قانون کا امتحان دینے کے فوراً بعد میں نے یہاں آ کر اپنے مرحوم بھائی سردار اسحاق خان صاحب سے کے چیمبر میں شمولیت اختیار کی، اور اس طرح 5 مئی 1985 کو لائسنس ملنے کے بعد میری وکالت کا باقاعدہ آغاز ہوا۔ آج کا دن اگرچہ میرے عدالتی منصب کا آخری دن ہے، مگر یہ ایک نئی زندگی کا آغاز بھی ہے۔ آج کے بعد میں اپنی ذات اور خاندان کو زیادہ وقت دے سکوں گا جو آج سے پہلے میں بطور وکیل اور بطور جج اپنی پیشہ ورانہ مصروفیات کی وجہ سے نہ دے سکا۔ اگر میں ماضی میں نظر دوڑاؤں تو اپنے آپ کو ایک ایسا شخص پاتا ہوں جس پر اللہ تعالیٰ نے ہمیشہ خاص کرم اور رحمت فرمائی۔ ابتدا سے ہی میں نے ماں باپ کو انتہائی شفیق و مہربان پایا۔ میں اپنی فیملی میں تمام بہن بھائیوں میں سب سے چھوٹا تھا، لہذا تمام بہن بھائیوں کو لاڈلا بھی تھا۔ میرے بڑے بھائی بہن بہت مددگار اور ہمدرد تھے۔ خاص طور پر میں اپنے بڑے بھائی جناب سردار اسحاق صاحب کا تذکرہ کرنا چاہتا ہوں، جو کہ نہ صرف ایک بلند پایہ وکیل تھے بلکہ بہت ہمدرد انسان۔ انہوں نے ہمیشہ میری مدد کی اور رہنمائی فرمائی۔ خاص طور پر وکالت کے پیشے میں سے منسلک ہونے کے بعد انہوں نے میری بھرپور تربیت کی۔ آج میں جس مقام پر ہوں اس کا سہرا کافی حد تک ان کو جاتا ہے۔ اس کے بعد اپنی شریک حیات کا ذکر کرنا چاہتا ہوں جنہوں نے میرا بھرپور ساتھ دیا اور نہ صرف گھر کو ایسے طریقے سے سنبھالا بلکہ بچوں کی بہترین تربیت کی۔ میں اپنے پیشہ ورانہ امور کی انجام دہی کے سلسلے میں اپنے بچوں اور شریک حیات کو مناسب وقت نہیں دے سکا، لیکن انہوں نے کبھی اس کا شکوہ نہیں کیا۔ ان کی بھرپور حمایت کے بغیر میرے فرائض منصبی کی بہتر انداز میں ادائیگی ممکن نہ تھی۔ میں نے اپنے عدالتی کیریئر کے دوران ہمیشہ سے یہ کوشش کی کہ ہر صورت میں انصاف کی فراہمی کو یقینی بناؤں. جیسا کہ آپ لوگ جانتے ہیں کہ نظام انصاف کا ایک اہم اصول ہے کہ چاہے 10 گناہگار سزا سے بچ جائیں مگر ایک بے گناہ کو سزا نہیں ہونی چاہیے. میں نے ہمیشہ اسی اصول پر عمل کیا اور جس مقدمے میں بھی استغاثہ اپنی بنیادی ذمہ داری یعنی ملزم کے خلاف مقدمہ کو کسی بھی شک کے بغیر ثابت کرنے سے قاصر رہی ہے، میں نے ہمیشہ ملزم کو شک کا فائدہ دیا. خاص طور پر انسداد منشیات کے مقدمات میں جہاں کی سزائیں بہت سخت ہیں، جہاں پر عدالت عظمیٰ نے یہ فیصلہ کیا کہ اگر مقدمہ کی ہر کڑی یعنی منشیات کی برآمدگی، مال خانہ میں باحفاظت موجودگی، فوری اور باحفاظت ترسیل اور مثبت رپورٹ میں اگر کوئی ایک کڑی بھی غیر موجود ہو تو اس کا فائدہ ملزم کو ملنا چاہیے. اس سلسلے میں کئی مقدمات کی سماعت کے دوران میں نے اعلیٰ حکام کو اس سلسلے میں کئی بار یاد دہانی بھی دلوائی. آئین پاکستان کچھ بنیادی اصول وضع کرتا ہے جس میں قانون کے حکمرانی اور اختیارات کی تقسیم شامل ہے. ان دونوں بنیادی اصول پر عمل درآمد کے لیے ایک آزاد عدلیہ ضروری ہے. یہی وجہ ہے کہ آئین میں عدلیہ کی آزادی پر خصوصی توجہ دی گئی ہے. اعلیٰ عدلیہ کے جج حضرات کی تعیناتی سے لے کر ریٹائرمنٹ اور برطرفی تک تمام تفصیل آئین کے اندر ہی فراہم کی گئی ہے. علاوہ ازیں عدالت کے بنیادی فرائض میں نہ صرف فراہمی انصاف بلکہ عوام کے بنیادی حقوق کا تحفظ بھی شامل ہے. یہی وجہ ہے کہ جب بھی کوئی ایسا مقدمہ عدالت کے سامنے پیش کیا جاتا ہے جس میں عوام کے بنیادی حقوق کی خلاف ورزی ہوتی ہو تو عدلیہ ہمیشہ عوام کے حقوق کے تحفظ کے لیے آئین و قانون کے مطابق فیصلہ صادر کرتی ہے، اگرچہ کئی دفعہ عدلیہ کو اس کی قیمت بھی چکانی پڑتی ہے. متعدد بار عدلیہ کو مختلف سیاسی جماعتوں کی طرف سے تنقید کا سامنا بھی کرنا پڑا مگر عدلیہ ہمیشہ قانون آئین کے مطابق فیصلے کرتی ہے. عدلیہ کی آزادی کا مطلب صرف انتظامیہ سے الگ ہونا ہرگز نہیں ہے بلکہ ایک ایسا وسیع نظریہ ہے جس میں جج کو نہ صرف تمام طاقتور حلقوں سے بلا خوف ہونا بلکہ سیاسی، معاشی اور معاشرتی طبقات کے تعصبات سے بھی آزاد ہونا ہے. بار کی بھی سوچ یہی ہے کہ اگر ایک جج کی مدت ملازمت اور تعیناتی کچھ طاقتور حلقوں کی طرف سے کیے گئے فیصلوں کی قبولیت پر منحصر ہوگی تو ایسے حالات میں عدلیہ کی آزادی ایک بے معنی جملہ بن کر رہ جائے گی. میں یہ یہاں واضح کرنا ضروری سمجھتا ہوں کہ عدلیہ فرد اور ریاست کے درمیان ایک ایسی محافظ دیوار کا کردار ادا کرتی ہے جس سے ریاستی طاقت ایک حد سے تجاوز کر کے کسی شخص کے انفرادی حقوق کو پامال نہ کر سکے. عدلیہ کے اس وقار کو برقرار رکھنے، آئین کی بالادستی و پاسداری اور قانون کی حکمرانی کو قائم رکھنے کے لیے انتہائی ضروری ہے کہ ایسے بلا خوف اور بلا امتیاز فیصلے صادر کیے جائیں جن سے کسی قسم کا سیاسی، معاشی اور معاشرتی طبقات کا تعصب ظاہر نہ ہوتا ہو. میں نے حتی الوسع کوشش کی کہ فیصلے کرتے وقت اس اصول کو مد نظر رکھوں. فراہمی انصاف کو یقینی بنانے کے لیے بار کی کردار کی اہمیت سے انکار نہیں کیا جا سکتا کیونکہ اس سلسلے میں عدلیہ کو بار کی مکمل حیات اور تعاون کی ضرورت ہے. یہی وجہ ہے کہ میں نے ہمیشہ بینچ اور بار کے مابین تعلقات کو بہتر کرنے کے سلسلے میں ہر ممکن کوشش کی ہے. یہاں مجھے یہ کہتے ہوئے خوشی محسوس ہوتی ہے کہ مجھے ہمیشہ بار کی جانب سے مکمل تعاون اور حمایت حاصل رہی ہے جس پر میں بار کے نمائندگان اور ممبران کا مشکور. بار کے ممبران کے لیے یہ ضروری ہے کہ وہ نہ صرف ہر مقدمہ میں مکمل تیاری کے ساتھ پیش ہوں بلکہ جب عدلیہ کو کسی موقع پر نامناسب تنقید کا نشانہ بنایا جا رہا ہو تو اس کا دفاع بھی کریں. یہاں میں ممبران بار کو مبارکباد پیش کرتا ہوں کہ جنہوں نے ہمیشہ عدلیہ کا بھرپور ساتھ دیا اور عدلیہ کے خلاف ہونے والی ہر سازش کو ناکام بنایا. میں امید رکھتا ہوں کہ مستقبل میں بھی ہماری بار فراہمی انصاف کو یقینی بنانے کے لیے عدلیہ کے شانہ بہ شانہ کھڑی ہوگی اور سائلان کو درپیش مسائل کے حل کے لیے اپنا مثبت کردار ادا کرتی رہے گی۔ میں فاضل چیف جسٹس صاحب کا شکر گزار ہوں کہ انہوں نے ریفرنس کا اہتمام کیا۔ میں نے قاضی فائز عیسیٰ صاحب کو بہت اصول پسند پایا ہے۔ جب قاضی صاحب پر ماضی میں ایک ریفرنس دائر کیا گیا تھا تو میں اپنے ساتھی جج صاحبان سے اور دوستوں سے پوچھا کرتا کہ کیا کوئی شخص قاضی صاحب کی دیانتداری پر معاشی ہو یا اخلاقی انگلی اٹھا سکتا ہے، تو ہر کسی کے جواب ہمیشہ نفی میں مل رہا۔ یہی وجہ ہے کہ اللہ تعالیٰ نے قاضی صاحب کو سرخرو کیا اور میں نے انہیں ہر طرح کے حالات میں اپنے اصولوں سے پیچھے ہٹتے ہوئے نہیں دیکھا۔ میری دعا ہے کہ اللہ تعالیٰ انہیں اس اعلیٰ منصب پر عزت اور احترام کے ساتھ فائز رکھے۔ اس موقع پر میں اپنے تمام رفقا جج صاحبان کا بھی شکریہ ادا کرنا چاہتا ہوں جنہوں نے فراہمی انصاف کے سلسلے میں میرا بھرپور تعاون کیا۔ خاص طور پر جو جج صاحبان میرے ساتھ بینچ کا حصہ رہے اور جنہیں میری وجہ سے دیر تک عدالت میں بیٹھنا پڑا۔ ان کی حمایت کے بغیر میں اپنی ذمہ داریوں سے بہتر انداز میں عہدہ برا نہیں ہو سکتا۔ اس کے علاوہ میں ان تمام جج صاحبان جو کہ مجھ سے سینئر تھے اور جن کی رہنمائی اور فیصلوں کو پڑھ کر مجھے بہت کچھ سیکھنے کا موقع ملا کا بھی شکریہ ادا کرتا ہوں۔ میں سپریم کورٹ کے تمام ملازمین کا بھی شکریہ ادا کرتا ہوں جن کی معاونت اور خدمات کے بغیر فراہمی انصاف کی ذمہ داری کو بطریق احسن ادا نہیں کیا جا سکتا تھا۔ میں اپنے دفتر کے عملے کا، جس میں میرے سینئر سیکرٹری سید عاطف حسین، سینئر سیکرٹری محمد سعید، ڈپٹی رجسٹرار ریسرچ سید سبت الحسن کا خصوصی طور پر شکریہ ادا کرنا چاہتا ہوں جنہوں نے محنت، لگن اور جان فشانی سے اپنی ذمہ داریوں کو ادا کیا۔ ان کے علاوہ میرے ڈرائیور عابد حسین مرحوم، ڈرائیور نواز، قاصد فیصل اور گن مین لیاقت حسین نے بھی اپنی خدمات بطریق احسن انجام دی۔ میں اللہ تعالیٰ کا جتنا بھی شکر ادا کروں کم، میں آج مکمل اطمینان قلب سے یہاں سے رخصت ہو رہا ہوں، کیونکہ میں نے جو بھی فیصلے کیے وہ قانون اور آئین کے مطابق کیے، اور فیصلے کرتے وقت کسی بھی سینئر اور جونیئر وکیل میں کوئی فرق نہیں کیا۔ اس طرح سائلان کو بھی ہمیشہ ایک ہی نظر سے دیکھا۔ عدل و انصاف کرنے والوں کو خوشخبریاں سنائی گئی ہیں، جن میں سے ایک یہ ہے کہ اللہ تعالیٰ روز محشر عادل منصف کو اپنی رحمت کے سائے میں رکھے گا، اور اس دن اس کے سائے کے سوا کوئی اور سایہ نہ ہوگا۔ مجھے کامل یقین ہے کہ میں اس دن اللہ تعالیٰ کی رحمت کے سائے تلے ہوں گا، کیونکہ میں نے ہمیشہ صرف عدل کرنے کی کوشش کی۔ مجھے یقین ہے کہ اللہ تعالیٰ نے مجھے جس کام کے لیے چنا تھا وہ میں نے احسن طریقے سے انجام دیا ہے۔ مجھے اس بات کی بھی آج خوشی ہے کہ میں راولپنڈی بار ایسوسی ایشن سے ایلیویشن ہو کر عدلیہ میں شامل ہوا تھا، اور یہاں سے احسن طریقے سے اور عزت کے ساتھ واپس اپنی بار میں جا رہا ہوں۔ آخر میں یہ کہنا چاہتا ہوں کہ عدالت میں بطور جج میں نے اپنے فرائض منصبی کی ادائیگی کے دوران حتی الامکان کوشش کی کہ ہر وکیل سے، چاہے وہ سینئر ہو یا جونیئر، بلا تفریق یکساں عزت کے ساتھ پیش آؤں۔ لیکن اگر مقدمات کی سماعت کے دوران مجھ سے کسی کی دل آزاری ہوئی ہو تو میں اس سے معذرت چاہتا ہوں۔ اس دعا کے ساتھ میں آپ سے رخصت چاہتا ہوں کہ اللہ تعالیٰ ہم سب کو اپنے حفظ ایمان میں رکھے اور اس آئینی ادارے کو دعام اور استحکام بخشے، آمین۔ شکریہ۔
Shukriya. Thank you, sir. I would now request the Honorable Chief Justice of Pakistan for his concluding address.
Bismillah ar-Rahman ar-Rahim. Assalamu alaikum. Honorable Justice Sardar Tariq Masood Sahab, my distinguished colleagues, Honorable Mansoor Usman Awan Sahab, the Attorney General of Pakistan, Honorable Riyazat Ali Sahir Sahab, Vice Chairman Pakistan Bar Council, and Honorable Mohammad Shahzad Shaukat Sahab, the President of the Supreme Court Bar Association. I have not written a speech. I would like to speak from the heart. My very honorable and distinguished colleague who's retiring, not today but on the 11th of March when it will be his 65th birthday, mentioned that his first encounter with the English language was in the 6th class. My first encounter with him was when I, as the Chief Justice of Balochistan, was attending a conference, and it was an international conference, and there were two entrances, one for foreign dignitaries and one for the rest of us. So the person at the gate said, "Sir, you come here." So the foreign dignitary on my right, he understood him with such a fair complexion that he couldn't possibly be a judge of the Supreme Court. And I thought he's a foreign dignitary, and then I later heard him speak in chaste Urdu. So I said, "Where did you learn Urdu?" That's my first encounter with him. And it has since been every encounter has been extremely pleasant. I did not know him before. Yes, he was from the district of Rawalpindi here, 1985. He became a counsel, then an advocate, then he became an additional judge of the High Court. 1987, he contested the bar elections as well and won as president. Thereafter, sorry, I beg your pardon, then in 87 he became an advocate of the High Court, and in the year 2009 he was appointed as an additional Lahore High Court judge, was confirmed, but unfortunately, though fully deserving of the position, did not become the Chief Justice of the Lahore High Court. The loss was of the province, the gain was of the Supreme Court when he was appointed on the 6th of November 2015 to the Supreme Court. He has performed, I would want to just dilate first on his judgments, a few judgments only. There are many of them. You've heard the figures, 13,000 plus. It embarrasses, I'm sure, not just me, but many of us. He was in between, he was not well, but despite that, he would say, "Kitne case lagao? Aap laga dein 40-50 cases. Aap kaise handle karenge?" He himself encouraged the maximum number of cases are fixed before him because he felt for those who had not had their say in court, and he ensured that they should as soon as possible. I just want to refer to a few judgments of his. One is the famous judgment of Asfandiar versus Kamran in 2016, SCMR 2084, in which, these are judgments which held something new, that there's a provision in the Code of Criminal Procedure, section 539B, to appoint a commission. And sometimes judges would appoint others as commission, and Sardar Sahib held that, and I'll quote, under section 539B of the CRPC, the trial judge had no power to appoint another person to visit the place of occurrence as a commission, because the report submitted by local commission cannot be equated with the memorandum mentioned in subsection 1 of the provision. A trial judge can inspect the place of occurrence but alone, and he cannot delegate his powers. So this was something which had been left unattended. In the same judgment, he also commented upon the fact that some lawyers have stopped reading different provisions available in the code and just move an application under the omnibus section 561A, and he correctly noted that this is not an alternate or substitute for an express remedy that is provided in the law, and unless there isn't, then recourse should be made to this provision. This was in 2016, now we come closer in time. Another judgment is the Model Customs Collectorate of Islamabad, versus Amir Mumtaz Qureshi, reported in 2022 as SAMAA 1861. And here his lordship dilated upon 249A and 265K of the Code of Civil Procedure to that rather than face a complete trial, these provisions can be availed of if there's nothing in evidence which may result in a conviction. However, if there's a possibility of a conviction, then recourse should not be had to these provisions. A few more, if I may just mention, that it's more recent, 2023, the case of Amir Faraz versus the state, 2023 as SAMAA 308, where his lordship cancelled the bail of someone, because generally we have very rare precedents in this regard, and he noted that misusing the same by hampering the trial, as on numerous dates of hearing the prosecution witnesses appeared before the court but their statements were not recorded on the request of the defense counsel, etc., etc., and that he was misusing his concession of bail. So bail was cancelled in this case, which is a misuse on people file cancellation of bails. They forget the parameters, the narrow parameters within which this relief can be sought, and his lordship identified these as mention has been made of the narcotic cases. I will just mention another one here, and that is that when the best evidence is available to the prosecution, this is the case of Ahmad Ali versus the state, 2023 SMR 781, and if it has been withheld for no good reason, then an adverse presumption will be drawn, and the benefit of that will go to the accused. One can go on and on, as all those who practice on the criminal side will know, that in fewer cases the law or something new is being said. So in civil cases you will find them all the time, but in criminal cases, because the principles are pretty well settled, or they just deal with the merits of the case and then really not attend to any legal point. But my distinguished colleague has always brought in the law in his judgments, which is useful not just for students of law and for lawyers, but also for his colleagues as well. Recently, mention was made of the Zulfikar Ali Bhutto reference case, which had been pending for a very long time. And one of the reasons which propelled me to fix it was that my colleague won't be with us for long, and he, more than anyone else on the bench, will be the greatest asset to ascertain the ins and outs and complexities of a criminal trial. So that was the reason which prompted it, and which at times I tried to hurry the case along as well, because I wanted his benefit of his elucidation of legal principles which he provided and how to attend to it, and we have attended to the matter and rendered our opinion to the President of Pakistan under our advisory jurisdiction. Another incident which many of you may not quite be aware of, and the role played behind the scenes, was after great, I won't say difficulty, but elections were announced, and then some petition was filed in the Lahore High Court, and an order was passed which would have effectively derailed the elections and would have made it impossible for the elections to be held on the scheduled date that had been given by the President and the Election Commission of Pakistan. This was when I had not taken a holiday for a long time, and I was visiting my ailing sister. And on that very day, we learnt of this. We convened and we requested it was in the evening of the 16th, the day, I think the next day was a holiday, was it earlier? It was end of December anyways, the holidays were, the next day was a holiday, and the Attorney General was called for, and the matter was attended to, the court convened. At that time, the three senior, myself, Sardar Sahab and Ijaz Sahab, we had requested him to join us in the deliberation, but he declined. So therefore, we requested